Hello, my name is Sue Miller, and together with Ed Davis, I head up the Banking and Financial Services Litigations Group at Stephenson Harwood. Welcome to the first in our autumn 2016 series of 4 short webcasts, in which we take a bite-sized look at some of the key themes emerging in financial disputes over the last 12 months. For the last 3 years, Donna Newman, a senior associate in our Banking and Financial Services Litigation team, has produced a webcast on the court's approach to financial mis-selling claims. In today's webcast, Donna will be providing a brief recap and then reviewing 2 more recent cases on this topic.
Welcome to our annual webcast on the court's approach to financial mis-selling claims. This webcast provides a brief recap on this topic, as well as a short update, covering a number of cases from the last court year. First, a brief recap. In essence, a financial mis-selling claim is a complaint by a claimant that they have been sold a financial product, such as a bond or an interest rate swap, which they should not have been sold. The financial mis-selling cases can be split into 2 categories. First, claims by those classified under the FCA rules as private persons, essentially individuals and other entities not suffering their loss in the course of carrying out business of any kind. And second, claims by non-private persons, essentially corporate entities. The importance of this distinction is that under Section 138D of the Financial Services and Markets Act 2000, or FSMA, broadly speaking, a breach of an FCA rule is actionable at the suit of a private person, but not by a non-private person, who has suffered loss as a result of the breach. Thus, a private person can sue a bank on the basis of a breach of statutory duty without having to show that the bank owed it a common law duty of care or that the bank acted negligently. This distinction between private persons and non-private persons has been the source of much frustration for claimants, and there have been a number of cases in which corporate entities have tried and failed to establish that they should be able to bring a claim for breach of an FCA rule. Recently, in the case of MTR Bailey versus Barclays, the claimant company sought to argue that it should be classed as a private person because although it carried out business in vehicles and property, it did not carry out business in derivatives or hedging or any other financial products. The High Court in this case rejected this argument, but MTR Bailey has since been granted permission to appeal to the Court of Appeal on this point. But on the basis of the law as it stands at present, a cause of action under Section 138D of FSMA is limited to private persons, which on present interpretation by the courts seems only realistically to cover individuals. Financial mis-selling claims by corporate entities, therefore, need to be founded in common law and so are often framed as claims for negligent advice and negligent misstatement. In order to bring a successful negligence claim, claimants must establish duty, breach of duty, and causation without relying on hindsight. One of the principal hurdles for a claimant to overcome when making a claim that they have been negligently advised is to establish that the bank actually acted as an advisor as opposed to simply a counterparty or a salesman, and that the bank assumed a legal duty to provide the advice carefully. In 2012, in the High Court decision in the case of Green and Rowley versus RBS, the court said that recommending a product is enough to constitute giving advice and thus give rise to the common law duty of care not to advise negligently. However, a bank is not necessarily recommending a product simply because it is providing information about that product. Simply presenting various products to the customer and discussing advantages and disadvantages does not, without more, amount to recommending or advising. Subsequently, in 2015, the High Court's decision in Crestsign versus NatWest Bank suggested that if a claimant was unable to reach the relatively high hurdle of establishing that the bank had owed it an advisory duty, it might still have a claim in negligence if it could establish that in relation to information that a bank had chosen to volunteer about a product or products, the bank had been under a duty to give that information fully, accurately and properly without misleading, i.e. a duty not to misinform. We said in our webcast last year that in the right circumstances, this duty not to misinform might provide an alternative basis on which a claimant could advance a financial mis-selling claim and might enable a claimant to establish that a bank is liable for its losses, even where the claimant cannot establish that there was an advisory relationship. However, this year in the High Court case of Thornbridge versus Barclays Bank, the court has said that this duty not to misinform is limited to a bank ensuring that any information that it in fact gives its customer is accurate and not misleading, and that there is no wider obligation to ensure that the information provided is full, accurate and proper. Using the dividing lines set out in Green and Rowley between advice and recommendations on the one hand and simply providing information on the other, the court in Thornbridge found that Barclays had only provided information about the products, i.e. that Barclays had remained a salesman and had not become an advisor. The claimant in Thornbridge also pointed to the fact that the bank's terms of business had stated that all transactions would be subject to the FSA rules and all other applicable laws, rules and regulations. On this point, the court concluded that this did not mean that the FSA rules were incorporated into the contract between the parties, and that this therefore did not assist the claimant in establishing a duty of care. In a case referred to earlier in this webcast, known as MTR Bailey versus Barclays, the claimant has been granted permission to appeal to the Court of Appeal on a similar point. It is worth mentioning at this stage that this year, in the case of CGL Group versus RBS, the court found that the bank did not owe its customer, CGL Group, a duty of care in relation to a general review of the bank's selling of interest rate hedging products that it had agreed with the FCA it would carry out as part of a compromise agreement. This was the case regardless of the fact that the review conferred a benefit on the claimant, because, the court found, in agreeing with the FCA to carry out the review, the bank had assumed a responsibility only to the FCA and not to any of its customers. Returning again to the Thornbridge case, another hurdle for the claimant in this case was that the terms of the contract between the parties, in the form of a swap confirmation, had contained a clause which expressly stated that the customer was not relying on any communication from the bank as investment advice or as a recommendation. A similar clause had appeared in the bank's terms of business in the Crestsign case and had operated in that case so as to negate the existence of an advisory relationship. Contractual terms of this type are often referred to as basis clauses because they define the basis or the scope of the relationship between the parties. Basis clauses are distinct from exclusion clauses, which is significant because a clause which seeks to exclude liability for negligence must satisfy the test of reasonableness under the Unfair Contract Terms Act 1977. Basis clauses, on the other hand, are not subject to this test. In Thornbridge, the court said that even if it had concluded that advice or recommendations had in fact been given by the bank, the terms of the basis clause would have prevented the claimant from asserting as part of its claim that the bank had given advice or recommendations. The court rejected all of the claimant's arguments that this clause should not operate in this way, including the argument that in reality the clause was an unreasonable exclusion clause. Going forward, basis clauses are likely to pose a real hurdle for claimants seeking to establish an advisory relationship, particularly as in the Crestsign and Thornbridge cases, the relevant clause appeared in standard form documentation. We understand that a hearing of Thornbridge's appeal to the Court of Appeal is due to take place in December. We also understand that the Crestsign case was settled before Crestsign's appeal was heard. Moving on from the issue of establishing a duty of care to the issue of establishing a breach of that duty, it has been a settled principle for some time in financial mis-selling cases that when a court is considering the question of whether a bank has breached its common law duty of care, it will take into account a bank's regulatory obligations to assess the level of skill and care that can be expected of the bank and whether it has acted in accordance with it. This year, the court has considered this principle alongside the long-standing Bolam test, in the case of O'Hare versus Coutts. The Bolam test derives from the 1957 case of Bolam versus Frian Barnet Hospital and provides that in determining the question of breach of duty, the question is whether the defendants, acting in the way they did, were acting in accordance with a practice of competent, respected, professional opinion. In the O'Hare case, the judge did not apply the Bolam test to the question of whether the investments were suitable and whether Coutts had breached its duty of care. He said that the expert evidence in the case indicated that there was little consensus in the financial services industry about how a customer's risk appetite should be managed by an advisor. He found that the regulatory regime was strong evidence of what the common law requires and that he would find that approach difficult to square with an application of the conventional Bolam approach, as the regulatory rules do not include reference to a responsible body of opinion within the profession. The judge concluded that Coutts had not acted in breach of duty and that the investments had been suitable. This case is also authority for the proposition that the fact that a bank's persuasiveness had influenced the customer in the direction of taking considerably higher risk than they had previously taken with their investments is not necessarily a breach of the bank's regulatory obligations or a breach of their common law duty of care. Indeed, in this case, it was found not to be. In summary, the cases from the last year discussed in this webcast demonstrate how difficult it continues to be for claimants to succeed in financial mis-selling claims. The present law on basis clauses, in particular, will be a significant hurdle in many financial mis-selling complaints, and we await the outcome of the Thornbridge appeal with interest. Despite these difficulties, there are still a number of financial mis-selling claims, either awaiting judgment or due to be heard shortly. We can therefore expect further developments in the law on financial mis-selling over this next court year.